much thanks to the BIOS Centre for inviting me. There's an interesting sort of continuity and discontinuity between my talk and Jan Willem's, because Jan Willem has been perfectly understandably talking about the important phenomenon of people being made to do things by other people against their conscience, against what they believe to be right. I'm going to be talking about the possible use of legal authority to change people's conscience through coercion. This isn't in any way a disagreement between us. It reflects a change in the way that people think about coercion that's actually going to be the subject matter of my talk. And so I'm going to be talking about legal authority, the authority of the state, and coercion in relation to that. And there's a very, very familiar feature of legal authority, the authority of the state. The state issues directives to us, legal obligations. You must do this, pay taxes at a certain rate, follow certain procedures. And if you do not do what we direct you to do, you will be liable to punishment. So we've got the direction, which is the imposition of a legal obligation to do something, and then we've got the coercive element, which is the threat of a sanction or punishment that will be imposed on you if you don't follow the directive. And legal philosophers often talk about, in this case, positive law and positive legal authority, human authority, that of a state, imposing these directives and backing up by threats of sanction. How to understand this? And how does this legal authority operate? And what's it in the business of doing? These are very fundamental questions. And they're at the heart of the problems of that area of philosophy that's often called not just political philosophy, but philosophy of law or jurisprudence, which is the attempt to understand legal authority and its operation. And one very central feature, which I'm going to be coming back to again and again, of legal authority is that it's directive. Now, what do I mean by directive? Well, it's kind of directing you to do something. It's issuing what looks like a bit of a command to do something, but it's not just mouthing off. It's not just speaking for the sake of speaking. It thinks it's got a capacity to change what you do. The whole point of having legal authority with all these directives is to change how the population of the political community behave, so that most people, not everyone, they're always going to be the offenders, most people will conform to the directives and act as directed. The law-abiding, at any rate, will do that. So directivity involves a kind of power, the idea of a kind of power. By power, I'm going to mean capacity to produce or prevent outcomes. And legal directivity involves a very interesting exercise of power by legal authority to prevent people from doing certain things, the legally forbidden, and to get them to do other things, the legally obligatory. Okay, and I'm going to come back to this notion of power. It's going to be very important. Now, if you go on a modern jurisprudence course or legal philosophy course, you will often be told about a really important debate in modern legal philosophy between legal positivists and natural lawyers. And this is a debate about the concept of law, how we are to understand the legal standards that are imposed on us directively. And the debate is in particular about the relation of these legal standards, these legal directives, to another set of standards, which we might think of as moral standards, or very specifically, standards of reason. Okay. So we've got the legal standards, which seem to be produced by humans, by human legal authorities. And how do they relate? How does our concept of these standards relate to something that isn't so obviously produced by humans, but but are thought about by humans, appealed to by humans, which are these standards of morals or reason. And the legal positivists, going back to people like Bentham and John Austin, are famous for saying, look, we've got a perfectly good understanding of legal standards and legal directives that's completely independent of appeals to morals or appeals to standards of reason. We can recognize legal authority quite apart from whether it conforms to moral standards or not. We cannot recognize the authority of the Nazi state. It's not very nice, but we can see there's a legal authority operating there, issuing legal directives and working perfectly well, though it's very, very immoral, and there's just no problem about that. And the natural lawyers seem to be in the business of saying, well, no, actually it's part of our concept of law, a positive legal authority, that it's got, at the very least, a kind of function in relation to morals or standards of reason. Our understanding of law is that it's about applying those standards. And indeed, so at the very least, even if the Nazi state is recognizable as a legal authority, our concept of law dictates that it's, because it's so radically apart from standards of reason and morals, it's an effective legal authority. And again, if we're trying to understand the content of law, it's very much part of our concept of law that we can appeal to standards of reason or standards of morals to disambiguate ambiguous legal standards or to resolve areas of legal disagreement. Okay, so there's this debate between the legal positivists and the natural lawyers about the relations between legal authority and a kind of standard, a standard of reason, which is very obviously an appraisive standard at the very least. We can grade laws as more or less reasonable, depending whether we're dealing with a Nazi state or a more just state. And this disagreement there is, as I say, a disagreement about how to unpack the concept of law and whether it is internally related through our concept to standards of reason or not. It's a very modern debate. And this debate is, as I say, about the relationship between one set of standards or a set of directives and another set of standards. It's not obviously a very fundamental debate about how legal standards operate or about the very nature of legal directivity, this power that legal authority has to produce or prevent outcomes at the level of the behaviour or actions of those subject to the legal regime. And if we look at modern legal philosophy, we'll generally see a very agreed picture about how law actually operates, how legal authority actually operates, how legal directives actually move us to conform. They basically look at a legal system as fundamentally about facilitating human cooperation. We all need to cooperate to survive. Legal authority is about facilitating that cooperation by providing security so that the ill-willed are restrained, and that we have nice, fully functioning traffic systems so that we actually get to where we want to get to on a Saturday morning in London. We're not working so well here, but there we are. That's the idea. And so on and so forth. So we've got a lot of widely shared desires or concerns for very fundamental sorts of goods, and the legal system is about organising human cooperation so that we all get these goods. And the power by which positive legal directives, the positive legal authority, the legal authority of the state moves us to conform is just ordinary causation. It's the same kind of power that if I chuck a brick at a window is involved in the brick breaking the window to produce an outcome of breakage. There's nothing metaphysically mysterious. I'll come back to the details of this, but the legal authority issues a law. We find out about it through an ordinary sort of chain of perceptual perception and cognition, and then I'll go into the details of this, somehow our mental states interact with our perception that this is what the law requires, and we act as the law requires. Okay. So we've got a modern debate about how precisely to understand the relationship between legal directions and standards of reason, but it doesn't feed through to a very fundamental, any interesting metaphysical debate about how legal directivity works, or a debate about how fundamentally, what fundamental job legal standards are doing. You'll see someone like John Finnest, who's a natural lawyer, telling a very similar story to this from Herbert Hart, or one of his successors is a legal positivist. And they'll very often look at someone who I'm going to be saying a little more about in the early modern period, Thomas Hobbes, and they will often describe him as obviously, in a way, a kind of natural lawyer. If you know anything about Hobbes, you'll know that Hobbes sees legal authority as a kind of coordinative system that provides us with security and facilitates cooperation to mutually desired outcomes like running traffic systems and the like. We set up the state in Hobbes's Leviathan to protect ourselves from the chaos of the state of nature, and this legal authority that's set up protects us and facilitates cooperation, and it operates through ordinary causation. But Hobbes is a natural lawyer, seen as a natural lawyer, not as a legal positivist, because he's got a conception of natural law as a set of theorems about how to preserve our life, following which leads us to set up the authority of the state, which then helps us better to apply these theorems so we all survive. The state enables us to survive, hence satisfies the ends of natural law. And so for Hobbes, the authority of the state is about a kind of applying natural law. So it's a very thin theory of natural law, it's just about survival. But he's a kind of natural law theorist. And he's sometimes even seen as a paradigm natural law theorist by modern writers on natural law. Okay. Well, that's quite weird if you go back to the early modern period, the 17th century, when Hobbes was writing, because Hobbes, I think, would have been seen by many of his opponents as the great destroyer of natural law, as the great enemy. And why is that? Because he's actually taking part in a completely different debate about the nature of natural law. And this debate is not some debate simply about the concept of law at all. It's a debate about how law fundamentally operates and what legal authority is about doing, what its function is. And this debate centres on the metaphysics of legal direction. So I've been talking about legal direction as something that's involved simply in positive law, in the exercise of the authority of the state to cause us to do certain things and to prevent us from doing other things. But when people used to talk about natural law, up to the time of Hobbes in the 17th century, they meant by natural law a kind of legal directivity that is exists prior to human legal authority. When they talked about a natural law, they thought that there was a kind of force or power moving us to do things that existed prior to any human legal authority. It was built into nature, this directive force. And it specifically addressed us as, to use Jan Willem's phrase, moral agents. And it was a force of reason. And this force of reason actually went on it was engaged by and facilitated by human legal authority, and was the very same force that eventually led us to conform to positive legal authority, at least when positive legal authority was moderately well working. And the natural lawyers believed there was this force of reason that moved us to conform, that was then involved in even moving us to conform to positive legal authority and explain the force of positive legal authority, its directive force. And it came with human nature. And what Hobbes is doing is denying that there is any pre-positive, natural, directive force. Why is he denying it? Well, he's basically a materialist. He thinks that the only force in nature, the only power in nature, is ordinary causation, bricks hitting windows, and what can be understood in terms of that force, which can be applied to explain the functioning of positive legal authority. What it won't provide is a force of reason that engages simply moral agents, human beings, not the bunny rabbits, and certainly not sticks and stones, in a pre-political way. And so there's the debate between Hobbes and the pre-Hobbesian natural lawyers about the metaphysics of legal direction, and it's associated with a further debate about what legal authorities do, what function it's serving, what's it about doing. Hobbes thinks that legal authority is simply about facilitating human cooperation. And it's about getting us to do or avoid doing things at the point of what Hobbes calls the voluntary, the point of what is subject to our will, to enable us better to satisfy generally shared desires, like drive on the left rather than the right, pay tax at a certain rate, don't steal other people's property, don't attack them. All these are actions that are subject to our will, that we can decide to do or not do simply because we've been legally directed to through a fairly familiar kind of ordinary causal process. So Hobbes is actually the origin of this modern conception of positive laws simply as a coordinative system that is now a common property to modern natural lawyers and modern legal positivists. What's the conception of the function of law that was believed in by Hobbes's opponents, the natural lawyers of the early modern period? Well, they didn't deny that legal systems are about facilitating cooperation. Obviously, everyone has always known about traffic systems. You got traffic jams in early modern Europe just as you get traffic jams now, and you had systems to resolve them. But they thought that the state was doing something much more fundamental than running cooperation. They thought that the state was about changing the way that we think. And here we're going to have a connection with some of the preoccupations of Jan Willem's talk. The state wasn't simply about getting us to do something at the point of what's subject to our will, whether or not we believe we ought to do it, to avoid some punishment threatened on us if we don't do what's subject to our will, like driving on the left or the right or paying tax at a certain rate. The law was about changing what we internally think we should be doing. The law was about coercively teaching us. The law was about facilitating the operation on us of a force of reason, which is a force of reason operating on us to lead us to form certain beliefs, those that are rationally justified, and avoid forming other beliefs, those that are rationally unjustified. And one of the very, very important features of the law was that it might include directions, not directives. Positive law might involve sets of directives, not just on what rate we pay tax or what side of the road we drive on, but what we believe. If you go back to early modern Europe, virtually every state in Europe, not just Catholic Europe, because of course quite a lot of these natural lawyers are Catholic theologians, but even Protestant Europe, contained heresy laws. These are laws, both at the level of the canon law of the church, but also the civil law of the state, that penalised you for holding certain false beliefs, or what were thought of as false beliefs, if you expressed your holding of these false beliefs or doubt in the true beliefs in the external forum, in the public forum governed by human legal authority. And the natural lawyers thought this was a perfectly good use of law. Hobbes is deeply opposed to this use of positive law to regulate belief, and is about remodeling both the metaphysics and the rest of the theory of law to remove the coercive regulation of belief, even as a theoretical option when you've got legal systems. It's just not a possible form of law for Hobbes. All that law can be about is regulating what's subject to your will to facilitate cooperation, like enabling you to survive. And you can't, on that basis, regulate belief, and I'll come back to that thought. Okay, so suddenly we've got a really fundamental debate about the metaphysics of law and the function of legal direction that's completely disappeared from modern jurisprudence. John Finnis hasn't heard about it, and natural lawyers haven't. And I want to actually suggest that actually this pre-Hobbesian natural law theory isn't something we should forget about. It's obviously a very important phenomenon. If you read the legal theory of Aquinas or Francisco Suarez or lots of other pre-Hobbesian legal theorists, they are natural lawyers in the old sense. And they link their legal theories to a very distinctive metaphysics of power and directive power in relation to law. But I'm going to suggest to you that what modern states do is much closer to what Aquinas and Suarez thought states are about doing, which is actually regulating belief. They're not obviously simple coordinative devices in the way that post-Hobbesian legal theorists think they're about. I'll come back to that. Okay, so we've got these two models of legal authority. One is legal authority is a kind of coordinative system, facilitating cooperation, regulating the voluntary, enabling us to get lots of things we all want, like protection and well-operating traffic systems and the like. And the other is legal authority as a kind of teacher that's changing the way we think, that's enabling us to share a common conception of how we ought to behave, of what's good and what's true. So I want to go back to early modern pre-Hobbesian natural law theory and look at how they arrived at this pre-Hobbesian conception of legal authority. If you look at the handout, I'm going to be, section 3, I'm going to be talking a little about the force of reason, because they think that legal direction works through this thing called a force of reason that only us as rationally capable adult humans are really sensitive to, that bypasses bunny rabbits and certainly bypasses sticks and stones. Unlike ordinary causal force, this force of reason involves only a very, very special part of the created world, human beings. And what is it? Well, supposing I try to argue you into believing something or into wanting and deciding on something. I'm not going to hurl a brick at you. I'm not going to exploit mere ordinary causation. Only very brutal people trying to change people's beliefs by bashing them on the head. I'm going to produce arguments. And I'm going to present you with what I'm going to call an object of thought, a potential object of belief, or in the theoretical sphere, or if I want to argue you into taking a decision, I'm going to provide you with another kind of object of thought, which is a potential object of decision, something you would decide on doing, or initially want to do, like buy a house, if I'm an estate agent. And I'm going to produce all these arguments. If I'm a mathematician, they could be proofs that this potential object of mathematical belief is true. I'm an estate agent trying to get you to buy a house. I'm going to provide you with lots of argument about how buying this house would be really good. So in the theoretical sphere, I'm going to produce this value, truth, and a lot of arguments to do with the truth, to do with evidence, proof. If I'm giving in the business a practical argument, I'm the estate agent, I want you to buy a house, I'm going to try to produce a lot of arguments to do with the good or the desirable. This is a really good house to have. At the moment, I'm just, in either way, dealing with an object of thought, something you might end up believing, or a possible outcome that hasn't yet happened, but you might eventually decide to make happen, that you buy the house. And I'm going to try and make the object of thought either look true or look good or desirable. And if you're rational, we've got the thought that the real evident goodness or value, the effectiveness of the proofs, the genuine evidence, will move you to believe what's true. And in the case of the practical sphere, the genuine goodness of a certain outcome will move you to decide on it. And even before it moves you to decide, it will move on you to want to decide on it, or want to buy the house. So we've got the thought that by leading you to contemplate potential objects of belief or objects of decision or desire, through your rationality, I can get you to be moved by the genuine truth or genuine evidence of the candidate for belief, or the genuine goodness of the candidate for decision or desire. And take away the third party. You yourself can inquire, what should I believe or what should I do? And you think of yourself as being moved by the genuine goodness of some outcomes to decide on those, the genuine badness of some other outcomes to avoid deciding on those, in the case of the theoretical reason, by the genuine evidence of some propositions to come to believe them, by the genuine disevidence, unlikelihood of some other propositions to come to disbelieve them or to remain in at least in doubt, keep well away from that one. So we've got a very, very inviting theory of reason here. Reason isn't simply a set of standards of appraisal, which is how I introduced it to you when I was looking at the modern legal debate. It actually involves a kind of force that will move us to believe what is true and to decide on what's good. And we are rational to the extent that we are susceptible to this force. One of the things that makes bunny rabbits really stupid or fall out of the realm of the reason capable is this force passes them by, let alone the sticks and stones. But we're really susceptible to this force. The more rational I am, the more a proof will convince me. And we will describe proofs in terms of the language of power or force. That's a really compelling argument. That compels me to believe it. That's a really, really good option. It compels me to decide on it. I can't resist that case for deciding on that one. Okay, so we've got this idea of a force. Modern philosophers still kind of think in this way. They talk about reasons as, by their very nature of reasons, having a capacity to move us. If we're rational, we are apt to be moved by the reasons. That's the language of force or power. If something moves you, it's exercising a power over you to get you to form what philosophers call a psychological attitude, which is an attitude of mind like belief or decision directed at a mental object. But in the early modern period, they take this metaphysics very seriously. And they think we have been created, to use another phrase that Jan Willem was already using, to bear the image of God, which involves our having a capacity to be responsive to this force as created beings, which moves us in the direction of the true and the good. And we're just built that way. That's a good thing. So why do we need the state? We're just built that way. Why doesn't the true move us to believe what's true, and the good move us to believe to decide on what's good, and life's hunky-dory? Well, it's not just that we're sinful and fallen, because that's part of the story, of course, because some people are not as susceptible to this force as they should be, and that's one of the effects of the fall, they thought. We've got the ill-willed, and then we might need a bit of protection and force in relation to them. But no, the thought was that actually, though as private individuals, we've got a perfectly good capacity at a general level to respond to the true and the good, there's one area where we are not naturally capable, and this has nothing to do with sin, it's just the way we're created. Though we're social beings, we don't have a natural capacity to understand what's good for what the scholastic philosophers, the pre-Hobbesian philosophers, called a complete human community. Here's an example. At a private level, we've got a general understanding of goods as things that we can distribute. That one person can have them and hand them to another, like, some food. And at a private level, I can think of you as needing food. Oh, I've got some, so maybe I should give you some food. As my neighbour, we don't want you starving. So I can also think that it would be very good for me to have some food. So we can think of goods as things that we might individually possess and transfer. But can we think of property as a completely public good that is the subject matter of a legal system with a law governing property and theft for a complete human community involving people that I have no personal direct personal connection with and never will have? Not someone I've just met in the forest clearing, but someone whose only relation to me is to be part of a political community. And their thought was, just as private individuals, we can't form an understanding of public goods like that and think about them very effectively. This isn't a conceptual matter, it's just the way we've been made. One of the functions of the state and of political authority and legal authority is to enable us, through living the political life, to take a genuinely impartial point of view and understand the good of complete human community, a bonum commune, as they used to call it, involving an understanding of property as a genuinely public good that's governed by impartial legal authority. So what legal authority is doing is giving us an understanding of the good as involves people who we have no private connection with. But so, we have, as human beings, to live in a community involving at some point. So what legal authority is about doing is facilitating the operation on us of the power of truth and goodness as it concerns the good of a complete human community. At the level of truth, it instructs us, enables us to understand public goods, what they involve, and at the level of practical decision making, the will, it helps motivate us towards pursuing those goods through cooperation within the institutions of the state. Turn over to page 2. Suarez characterizes legal authority in De Legibus on laws and God the legislator. In the early 17th century, Suarez is a Spanish Jesuit political philosopher, one of Hobbes's bêtes noires, his hates. Yet humans as individuals have difficulty in knowing what furthers the common good, the good of a complete human community, the bonum commune, and moreover, rarely strive for that good as a primary object. Not because we're sinful, but that's just because we're the way we're made. We don't have that perspective. So that in consequence there was a necessity for human laws that would have regard for the common good by pointing out what should be done for its state, for its sake, by compelling the performance of such acts. So what the state is, it's a kind of coercive witness for the truth concerning the bonum commune. So when the state issues a legal directive or set of legal directives, it's not simply facilitating sort of cooperation. If it was just like traffic systems, we all know what's involved in getting from A to B. We're just a bit confused how to set up the coordination of the system. No, this is much, much more profound. What the state is doing is instructing us about the good in itself, like the good of property in itself, or the good involved in other people's human dignity in itself. And what the state does when it's issuing laws directing us not to steal things or not to attack other people is it's standing as witness to some value that those legal directives are about protecting, like the value of property or the value of human dignity when it comes to stopping people murdering or in other way aggressing on other people. And the function of punishment, threats of punishment, aren't simply to act as incentives to incentivize us to avoid certain forms of action at the level of the voluntary. Or I better not attack them or steal from them, otherwise the state will whack me. But the threats of punishment are a further act of communication. And what this communicative act is doing is saying, these values are so important that legal authority is justified in protecting them with threats of coercive force. You know, thieving or attacking other people is so damaging to the common good that it deserves legal authority coming along to you if you ever do it and punishing you. And even before you ever get to that stage, perhaps you never do, the threats of punishment operate on you communicatively because they lead you better to understand that the value of property is so very important. Okay. So when the judge, for example, sends Bloggs down for 10 years for theft, he'll very often say something like this: right, Bloggs, I'm sending you down for 10 years, mate, to send a message to everyone how valuable property rights are, how morally terrible it was for you to have this disregard for them. It's a message to everyone what property means. Of course, supposing you've been stolen from, and suddenly the judge, in the case of your theft, said to Bloggs, "Oh, Bloggs, you stole from you. Oh, well, that doesn't matter. We'll just make you do 10 seconds, slap wrist chaps." You'd be very annoyed because there'll be an implied message that property rights in your case don't matter very much. So punishment and threats of punishment are communicating a message that are also, obviously, is communicated through the legal directives in the first place, that certain things are really important and you better believe it. Which is why, of course, they thought there was no problem about the state legally directing not just voluntary actions like whether you steal or not, but belief itself as well. They thought that certain beliefs were so important to the good of the community that if someone failed to hold them, and moreover expressed that disbelief or doubt in the public sphere, this would be really damaging. And so the state was fully justified in requiring you to hold those beliefs and threatening you with punishment if you ever expressed your failure to believe them in the external forum where the state can get you, when the state can see what you're up to, so to speak. And of course, in the early modern period, a central good to the bonum commune, a central part of the bonum community, was obviously religion. And so states tended to have things like heresy laws. Okay, which Hobbes did not like. I won't go into, it's very, very important for Hobbes' political system that there be no heresy laws. But there's no time for me to explain why. It's rather fascinating why he is such an enemy of them, but he's definitely in the business of getting rid of them. But if you look at modern states, there are very often things very like heresy laws. After all, I've just been talking to you about the law on theft. And I've been saying, if you understand the law on theft, though it may not directly regulate your beliefs about theft, it's clearly using threats of criminal sanction to mould the beliefs of everyone in the community about the importance of property as a moral good. I mean, if we relied on to stop people on thieving simply from threats of punishment that worked simply through fear of punishment at the level of the voluntary, we'd have to have a massive police force, and it would have to be very good at what it was doing. And probably the threats of punishment would have to be very meaty, because if all that you were relying on was fear of being punished to stop people stealing, well, that's going to be tough to run. What you want is for most people never to think of stealing in the first place, because they're thoroughly convinced that theft is wrong. And why are they so convinced that theft is wrong? The criminal and law and theft is part of the story, which for all good bourgeois is part of their upbringing. It's part of the cultural forum, cultural environment produced by the state and its regulation. But you even nowadays get something very like law's directive even of belief in many modern states. Most states in the continent have, that used to, in countries that were once occupied by the Nazis, have Holocaust denial laws. Now, Holocaust denial laws are modern heresy laws. They may not directly be presented as regulating what you believe, but what they do is they punish you for expressing disbelief or doubt that the Holocaust happened. They're everywhere in continental Europe, and it's an amazing number of countries now have them. And they penalise public expression of doubt or disbelief in an historical fact, just as early modern heresy laws punished disbelief or doubt in a religious claim. Because belief that the Holocaust really happened is now seen by the modern state as important to the bonum commune, rather as religious belief was once seen as important to the bonum commune. Well, what's Hobbes about? Well, Hobbes doesn't believe in this force of reason. He's a materialist. I mean, this force of reason is a kind of value operating on you through an object of your thought. What the heck's that? There's many metaphysical problems here. And it's a force that only operates on adult human beings. It passes bunny rabbits by, and it's clearly nothing like brick sitting windows. And it's supposed to move you. It's fundamental to this whole pre-Hobbesian natural law theory that there is a force of reason to move you that legal authority can facilitate the operation of. And there is such a thing as an exercise of rationality that's responding to it. For Hobbes, there's no such thing. He was a materialist. He thought all there was is bricks hitting windows. So we need a model of how law directs you that operates, that can work in material nature. So there's not going to be nothing prior to human legal authority that's going to be involved in legal direction or laws moving you to do things. All that's going to happen is that there are going to be certain things we will want. Now, our wants are material states of our mind, and they're widely shared at a certain level, like desires for survival and for well-functioning transport systems and things like that. Legal authority never moves us to form radically new psychological states in the first place by operating through an object of thought to move us to form beliefs or desires in the first place. All it will do is interact with these generally shared motivational states, these generally shared desires, like desires for survival and the like. And how will it do it? Well, legal authority will come along and say, we direct you to, and if you don't, we will whack you. But the function of the threat to whack you is simply to engage with an existing motivation that you have to survive and to avoid being whacked. So this is a desire to do things at the level of the voluntary that are required to avoid punishment. And it's generally thought by Hobbes that we'll generally share not just a desire to survive, but once we've got functioning legal authority, we'll generally have a desire to do whatever the legal authority orders us to do anyway. Why? Because we all understand that a lot of our other generally shared desires, like to have a nice transport system, will be better satisfied if, in relation to things like transport, we do whatever the legal authority requires us to do or directs us to do. That will better enable us to satisfy all these other desires. So we've got a desire to survive, a desire not to be whacked, a desire to get a lot of other goods that state coordination can better enable us to get, and all these will interact with our perception through a materialistically understood perceptual system that legal authority has directed us to do something, and so on the basis of that, we do what the legal authority has directed us to do. Drive on the left, don't steal, pay tax at a certain rate. And so legal authority operates. What legal authority can't do on this understanding of it is require us to believe something. Because the regulation of belief is no longer about legal authority facilitating, by acting as a witness, our response to evidence for the truth. All legal authority is doing is about engaging with our will to do whatever legal authority requires us to do within a certain sphere, and further incentivizing us to obey those directives by threatening us with punishment. And the threat to punishment we're supposed to respond to is simply out of a desire not to be punished. Well, I can't understand directives on belief like that. I can't say to you, believe that the Battle of Hastings took place in 1065, or I will whack you. Because that directive, just on its own, backed by the theory of punishment, is nothing to do with evidence of truth. I'm not working like a witness for the truth. I'm just arbitrarily decreeing that you form a belief and relying on your will to do whatever I say and your fear of punishment to do the work. Well, it won't, as Hobbes said. As for the inward thought and belief of men, which humane governors can take no notice of, for God only knoweth the heart, they are not voluntary, nor the effect of the laws, but of the unrevealed will and of the power of God, and consequently fall not under obligation. So that the state is not in the business of regulating belief and cannot be. And this idea that belief can't be regulated because it's not voluntary is part of the mantra of modern post-Hobbesian liberalism. You can't regulate belief because what you believe is an inner sphere that somehow escapes the coercive authority of the state. And so if legal authority is ever directing you or coercing you to do something, we've got to look at it as in the business of making you do something at the level of a voluntary, which you probably think you shouldn't do, which is what Jan Willem was talking about. But of course, for this pre-Hobbesian theory of legal authority, actually the fundamental job of legal authority was about changing what you think's right in the first place. If it's dealing with a lot of people it hasn't convinced at the level of their inner belief, it's kind of failed at a very important level of its job. And indeed, a lot of these pre-Hobbesian natural law theorists were very, very hot on people not acting against their conscience. They thought that was very bad, which is why it was all the more important for an orderly public sphere that legal authority change your conscience and not regularly be getting you to act against it. Which is why they thought that actually the legal regulation of belief was a way of respecting people's conscience, not an assault on it in the way that modern liberalism tends to suppose. So there I'll stop.
Well, thank you on behalf of us all. I think that was a tour de force. Any questions? And I'll use the mic this time. Or do you want to mic me up? I'll use this one.
I'm wondering if, out of that argument, there comes one that suggests that a state should be socialist or at least provide a certain level of equality, because it seems to me like states which are able to use their ideological power and convince people to follow a certain way of thinking tend to be able to do that for people that benefit from the state. And kind of thinking about the context of people who've written on state and talked about it, it does tend to be people that benefit from it. It's relatively privileged male kind of white people, right? And especially like natural law as well, there's a lot of kind of structural inequality that comes up in a lot of the question. So then I guess in societies today still as well, you have people who, on the whole, perhaps don't benefit from the state. They're not going to get a lot out of it, and we have to use coercion to be able to kind of provide, to be able to maintain the state, basically. So, do you feel that the states, in order to be able to persuade and have that ideological power, that there should also be a certain level of equality or socialism or something?
That's it's a really important question. What's fundamental to this pre-Hobbesian theory of legal authority is that it understands legal authority as a kind of epistemic authority. So you're inclined to obey the state, whatever the bearer of legal authority is, because the state is a credible witness to you. You immediately, why when the state asks you to believe something, do you form the belief as legally required? Well, it's not out of sheer of punishment, because we've seen that doesn't work. It's just that you hear the threat of punishment as communicating an important witness. But that means you must think that the state has some kind of knows. And one of the really interesting historical questions that arises out of this is, I think actually this is how legal authority does work. It is epistemic. The pre-Hobbesians were probably right. But if that's right, what does change over time is what the state is good at legally regulating. And that involves a change in where the state is found epistemically authoritative, where the state's credibility lies. Here's an example. Until about the mid-17th century, political authority is actually very effective at getting people to change their religion. You get things like the Habsburg state in Austria. Late 16th century, Vienna is a Protestant city, as is much Upper and Lower Austria. When Elizabeth I comes to the throne of England, England is largely still a Catholic country. The Marian Restoration was very successful, almost because nothing had changed anyway. But the Habsburgs in one direction, Elizabeth I in the other, used legal authority over a generation radically to change people's religion, very successfully. After the mid-17th century, you can't do that anymore. When rulers change their religion in Germany after the mid-17th century, like in Saxony, the population doesn't change their religion, and they can't make them do it. With COVID, very interesting, the state was very good at regulating what people did at a very fundamental level of their social life on the basis of its access to scientific expertise. It was as efficient at preventing you seeing your nearest and dearest, some of whom were dying, as the early modern state was at getting you to change your religion. In both cases, it's amazing that the state managed to do either thing, actually. Particularly if you've got an instinct for libertarianist conceptions of liberty. How's this happened? How did it happen? I'm kind of thinking, I'm not sure socialism necessarily may be the full story. Of course, the provision of benefit is very important. In the case of the early modern period, the state was seen as having an expertise in relation to something was a benefit to you, namely your destination in the next world. Now we see the state as having an expertise in relation to something that's benefit to you, whether you get a certain germ or not, or suffer the consequences of it if you do get it. So I think the question, my answer to your question is, look at what a state is seen as having expertise in relation to, where the common good is concerned. There you will get the state being a very effective coercive regulator, and at the level of opinion. Because, of course, a lot of what the state is doing under COVID is, whether it was very open about it or not, through various forms of pressure, regulating what was said about, say, vaccinations, etc., in the public sphere. They were shutting stuff down very rapidly.
Thanks, Any question, Patricia? Thanks for the great talk. I just wanted to ask you to help me to understand what is the philosophical approach in modern law now? I mean, the short-term rules about COVID would suggest they're reverted to the pre-Hobbesian natural law theory. We've got hate speech laws. A very draconian one in Ireland has been enacted, or is about to be, whereby if you don't show what's on your mobile phone to the Gardaí, you will get 5 years in jail and you will be assumed to be guilty of something. It's really,
wow.
really draconian. And thankfully, the public are beginning to react against it. But in general, what sort of theories and what's the general philosophical approach in laws at the moment?
Well, I think there's what states do, and there's what philosophers think about what states do. And what I think is that those are two amazingly far apart at the moment. I mean, if you look at, say, I'll wave my flag. I'm a Roman Catholic, as someone like John Finnis is. John is entirely a post-Hobbesian natural lawyer. He thinks that it's not really possible for legal authority to regulate belief. And he certainly doesn't think that it's particularly correct for it to do so. And he will write endless articles about legal systems as coordinative systems. So you know, I mean, I think quite a lot of the new natural lawyers work that way. And I can assure you that my secular liberal colleagues are entirely the same. But they have noticed that states are decreasingly publicly interpretable as working within that post-Hobbesian framework. They don't seem to be simply coordinative devices governing the voluntary. They do seem to be in the coercive education business. And one of the reasons I spent the last academic year out in various parts of America was because I mean, one very amusing visit to Berkeley where I was invited by various disciples of rules. One of them was a well-known rules people, to talk to them because they can see what states are doing, but modern legal and political theory does not really have a framework for explaining this. It's particularly not got a conception of how law moves us to conform to explain this. In fact, actually, they don't normally discuss by what power does legal directives move us to conform. That's amazing, actually. Fundamental feature of how legal systems operate is that they issue all these directives and a lot of people start following them. How does that work? There is not, in any normal modern legal textbook that I read, a chapter on the metaphysics of legal direction. And that's because they tacitly assume it's just ordinary causation. And they've got something like the Hobbesian model at the back of their mind. But that won't work with the legal direction of belief. That's not how Holocaust denial laws, which is clearly about stopping you disbelieving in the Holocaust, work. And what they obviously, one way of trying to deal with the matter is to do a new metaphysics of the power of legal direction. But then you've got a kind of metaphysics that is just not on the menu for modern legal theory. It's too radically revisionary of the metaphysics of power and causation. And that's the problem. Plus, I think that the self-conception of the state as not in the business of coercively educating is too powerfully entrenched in the modern ideology of secular liberalism. So there's a metaphysical problem, which I've just been describing, but there's also a self-image problem. That is, we don't really want to have states doing this sort of thing, even if they do it. So we don't really want to think about it. That's actually been particularly influential in modern Catholic thought since the Second Vatican Council, where people like John Finnis will be very, very keen to distance themselves from the coercion of religious belief of the sort that the preconciliar magisterium, in its theories of religious toleration or its absence, went in for. So there is also a liberal ideology. What I would suggest is actually there might be a liberal ideology, but there's not really such a thing as a liberal state. It's not as if there's a pre-modern illiberal state that works in the way that the old pre-Hobbesian natural lawyers thought, and then somehow Hobbes created a new kind of state that doesn't do that sort of thing anymore, and that's the modern state. Actually, I think states have always been in the coercive education business, but for a considerable period of the last 100 years or 150 years, for various reasons, they've had a public ideology that's in denial about that.
Any final questions? One speaker to another?
I think I agree with most of what you said, but I wanted to ask if you can clarify a bit more exactly what kind of teacher the state would be, because it seems to be that it's basically partly the state knows best, and therefore you shall follow the proclamations and propagate as truth what the state claims about COVID or whatever it claims to have some epistemic authority on. But it doesn't, at least the way you presented it, there doesn't seem to be a lot of argument. It might explain its view, but you don't get to challenge the view, at least not as you introduced. So it becomes almost, how do you say, if it's really teaching in the sense of making people understand, I completely agree that if you come to believe, yes, this is true,
Yeah, yeah.
Is that correct?
Yeah, well, that's an excellent question, and there are two dimensions to it. One is what precisely is the basis of the state's epistemic authority? Where does that come from? And what's it supposed to be doing to us? Is it meant to be giving us a complete understanding, or is it something else? Can I start with the one and then move on to the other, because they will slightly connect? There are two aspects to this model of state authority as epistemic. One is a thought about the nature of political institutions. And that's the one I rather presented in the talk, which act as enabling us to adopt a kind of impartial point of view. As you are involved in the political life of the state, as you participate in the operation of its institutions, you develop an understanding of an impartial point of view that without political institutions you could never have had. Which I find a very, very appealing thought. It actually doesn't obviously mean that a single ruler is the person that knows and everyone else is ignorant, because it looks as though a kind of point of view with an understanding, and I'll come back to what that involves, comes with your interacting in political life with state institutions. Not simply as someone subject to their direction, but somehow participating in them will enable you to get a better understanding, more sharing of the impartial point of view. And it might well suggest things like a certain view of democracy as actually a legitimate development of this view of the state as an epistemic authority, because it will then lead to a shared understanding. The more participation in political institutions is shared, as in something like democratic life. And it's not a coincidence that the early modern Jesuit political theorists were, Simon like Suarez in particular, were very interested in democracy as the original form of government and as one that should not be dismissed. That's why James I had these people's works burnt by the public hangman, because they didn't believe in the divine right of James I as a single ruler. So one way of understanding the epistemic authority of the state is through the idea of a point of view that is made available to you to the degree to which you are interacting with and participating in institutions general to a political community, political institutions. The other is the thought that the people running a state are very often tightly linked, such is the way that human societies work, with other holders of expertise in a way that the ordinary citizen isn't. So in the early modern period, they knew other sources of authority, possessors of epistemic authority in relation to religion, namely they were in cahoots with the clergy, who might be seen as the ultimate holders of epistemic authority in matters of religion, but the rulers of the state would be particularly linked with those. Nowadays, of course, the rulers of the state claim to know the scientists, and they say, well, of course, we're going with the science, but of course we know what the science says. You with your ghastly little Twitter feed on vaccinations clearly do not, so shut up, mate. Now, this is actually not at all to do with democracy. Here's the state having a direct line to some people who know, and it's talking to you on the basis of having that privileged access to what's known. And here, of course, the state's authority is much, much less obviously connected with something that could widen into something like a more general understanding. And here it looks as though you're just being told something, but not told why. And that may be all that's going on. And to a level, actually, I thought that might be good enough. Look, it's really important that everyone understand that the Holocaust did actually happen. It's of secondary importance that they know the arguments. They just should have a thought that it did happen and a tendency to disregard anyone else who says it didn't, because they'll be less likely to be anti-Semites or whatever. Or they should believe that everyone, whatever their ethnic background, has the same ethical status. They shouldn't know what the arguments for that because then it's going to get very, very, very complicated, because as we know, the human dignity notion is a very complex one and subject to much philosophical debate. And what we want is for everyone to have this shared understanding of everyone being the same level of dignity. That's the really important matter. When you look at someone like Suarez, who's a very sophisticated theorist of this sort of thing, he kind of actually sees authority as operating in a dual way. It's actually both just acting as a witness for a truth in a way that can be detached from a lot of people ever coming to any understanding. But sometimes he sees legal authority as guiding you to the arguments and ensuring that you actually attend to them. So it's actually an authoritative argument provider, or not so much an authoritative argument provider, an authoritative director of you to arguments. Now, it's not simply directing you to form the belief as a result of following some directive to attend to arguments. It's actually directly directing you to form the belief. But he sees its function as also to, at some point, and it would be very good if it got you to attend to the arguments as well. But he also thinks that a lot of the time there's just no question of that. I mean, for example, everyone should believe in God. But there can again be lots of people who are never going to understand the arguments as which he believes in, the rational arguments for the existence of God. And so the state's got to operate at more than one level. It's going to have its friends, the philosophers, who've got all the arguments. And then some people, the more sophisticated, will end up reading the arguments, thanks to the state bringing the whole matter to their attention. Other people, the chap ploughing the field, etc., it'll never get to that. But it's so important they believe in God, just as it's so important that we not have racist beliefs. It's so important that we believe the Holocaust actually happened. It's so important that we believe that vaccines work and we should all be taking them, etc. They just think witness to the truth is enough. And we do believe a lot of things just on someone's witness without knowing the arguments. Most of my beliefs about science work that way.
Well, thank you very much, Professor.